SJC-11816, John W. Murray v. Town of Hudson.
Good morning. May it please the court. My name is Brian Murray. I'm the attorney for the appellant in this case. We're going to be asking the court to reverse the motion for summary judgment, which was granted in the lower court to the benefit of the town of Hudson. The facts in this matter are fairly straightforward. On the evening of May 15th, 2010, there was a baseball game between the Milford High School varsity and the town of Hudson varsity baseball.
Could I just ask you one question about that? With respect to the time of the game and when the game was being played, is it true that the field was not open to others? In other words, you couldn't have had a pickup softball game in another part of it?
Absolutely. It was a closed...
And the evidence shows that? Absolutely,
unquestionably. It was a closed athletic event, similar to all of the types of high school, whether it be football, baseball, basketball, and the field, Riverside Park, which is owned by the town of Hudson, under the control and jurisdiction of the school department of the town of Hudson, was closed to the general public at that particular time, other than spectators who may be able to watch the game. But the playing field itself was limited solely to the players from Milford, Hudson, coaches, and umpires.
So lots of towns have fields, so your argument would be if it was a person running around flying a kite on the field, that 17C would protect the town, right?
I think the distinction really is whether or not it is open to the public.
At the very specific time when the event is happening? All
exactly.
Right, so lots of towns, certainly my town, has voluntary organized softball leagues, and you sign up for a field. And if no one's signed up, you can play pickup softball, do anything you want on the field. You sign up, you sort of have the right to use the field for a period of time. Would those softball players be able to bring suit for a defective bullpen?
Well, I think it depends, again, on whether or not that field would be open to the public at that particular time. I think the scenario that you're alluding to would be a permit process, presumably set forth.
Sign-up process. You call it a permit process, whatever you want.
Absolutely.
It's a sign-up process.
Absolutely. So I think inherent with that process is the expectation on the particular softball team that that field is going to be closed.
That's special permission. That's just not the... So the town would not be protected under 17C if it had a sign-up thing for their fields.
Correct, but again, I think in terms of just the sign-up, I think you need to go a little bit beyond what the parameters of that sign-up means. Does it just mean that you can go and use the field along with other folks, or does that permit give you exclusive use of that field for that particular time? Typically, that's what occurs, and when that happens, no, the field is not open to the general public. The field is open to that specific softball team that may play at a particular time.
So your argument doesn't rely, then, on this special relationship between the town and athletes who are playing in high school games?
It's two-part. It's two-part. The question of whether or not the appellant was a member of the general public is certainly an issue that goes to the applicability of the recreational use statute, but also the fact that the Alter case really took students from schools out of the parameter of the recreational use statute is very important because it says that schools owe a special duty of care to their own students.
So if we decide the case the way you have described it, my sense is towns are not going to perhaps allow these sign-ups because all of a sudden that makes them liable, where if people just showed up and played a softball game, and shoot everybody else off the field, and the town wouldn't be liable.
I don't think that that's going to change the general policy considerations that exist right now. In the scenario that you're projecting, when there is that specific sign-up and when there is the exclusivity of use of a particular team, the recreational statute would not apply. And of course, the other matter that comes in is the payment of a fee. That also precludes the use of the recreational use statute. Typically, those softball leagues do require payment of a fee. That in and of itself would abrogate.
Well, some towns are very generous.
Well, we had a case about that, the payment of a fee for a softball league, which I think I wrote, but I can't remember the name. But that's what you're talking about, that kind of.
Right. The recreational use statute, Chapter 20, Section 17C, only applies when the landowner allows the use of the land without payment of a fee.
But there's no suggestion here that there was payment of a fee, right? I mean,
Correct.
because this was used by the local schools, the Milford School and the Hudson School. Right?
Correct. It was under the...
It was the home field for the Hudson schools.
Correct.
And there's no suggestion that there was a financial arrangement between the schools and the town.
No. That aspect of the statute does not come into play here. I think the aspects that come into play in this particular case are, number one, the appellant, Murray, was not a member of the general public. He was a subset, a discrete unit, i.e. a member of the Milford High School varsity baseball team that was allowed access to the field at that particular time. And secondarily, Hudson clearly owes a duty of care to its own students through the Alter case, and that same duty ought to be extended to a subset of the class of Murray.
Do you need to go to the Alter analysis if you exclude someone who is injured from the class of general public? I mean, isn't it only use by the general public that is covered by the recreational use statute? Do you also need any kind of a special relationship? Are you talking about, so first you have to be excluded as a member of the general public, and then Alter says you also rely on. But does Alter even talk about this exclusive use or being excluded from being a membership in the general public?
Isn't that more a Wilkins question?
This case is highly analogous to Wilkins. I think if you substitute parent at PTO meeting for visiting student athlete, you have the same case.
Irrespective of any question of special relationship or duty.
Right.
Well, I would submit that the special relationship or duty is applicable because it is clear, and it has been held, that schools do have a special duty of care to their own students.
I guess my question is, do you need both? I mean, can you go on the special duty and say, well, it doesn't make any sense to just have it be for the town to its own students? It would cover any student, on that analysis, or...
Well, I mean, I think that's an interesting point, and I think if you look at the other jurisdictions that have handled cases like these, which we've cited, the state of Washington, state of California, state of Rhode Island, which is the case is almost on all fours, those courts looked at the analysis as the way I'm projecting both, that, number one, the appellant was not a member of the general public, and number two, schools do owe that special duty of care to their own students, and that ought to be extended to students who are invited to participate in that school's sponsored, controlled, regulated event, i.e., which was the baseball game for which the town of Hudson was responsible for in the field.
But to be clear, I think her question is, if you do not prevail on your view that the field was closed and therefore you win on that ground, can you still win on the view that schools owe a duty when they invite another high school to play to provide a field that is safe for that team?
I'm sorry, I don't understand that particular point.
Basically, you're making two alternative arguments. The question was, do you need to prevail on both 1 and 2, or can you prevail on 2 alone?
I would think, I guess, I hadn't really analyzed it that way in looking at the other decisions, but for the mere fact that the appellant, Murray, was not a member of the general public, that in and of itself ought to preclude the use of the recreational use statute. Absolutely.
Now,
I don't.
do we need then to revisit Kavanaugh versus Trustees of BU for you to prevail on that point?
I think the Kavanaugh case is an interesting one, and I think it is quite different than the case before you today. The Kavanaugh case, of course, focuses on a scholarship athlete situation, and much of the language in that case on this particular point talked about the benefits that a college would derive from its own scholarship athletes in terms of attracting crowds and attention, the benefits that the scholarship athlete derives from the college in terms of financial, the education, the housing, and that sort of thing. And it made clear that a visiting school does not share in that same type of financial benefit. I think that's one of the important distinctions between Kavanaugh in this case. And then I think the second distinction, which is, I think, quite significant, is that Kavanaugh involved an intentional tort. It was a assault and battery, that type of thing. And when you read that decision, it talks about the foreseeability, or I guess the expectation of prevention of that type of a harm to be in the hands of the officials, the game officials, in terms of fisticuffs and that type of thing. Here we have a public school student in a system that's regulated by the state through the MIAA, and there's not a question of any scholarships or money transferring from the student to the university, and it's a negligent case. It's not an intentional tort. It's not the type of injury that one would expect an umpire to ordinarily try to prevent.
Can you speak a little bit about the issue of the presentment, as to whether or not your presentment is limited to negligent design as opposed to negligence?
Absolutely. The purpose under Chapter 258, Section 4 is to really allow the municipality to investigate claims, whether or not claims are valid, to preclude payment of non-valid claims, and to settle valid claims. Now, the claim letter that was initially sent clearly does state the word negligent, but I think even more significant than that, it details the area in question where the injury occurred, and it details quite clearly the facts of the claimed injury. And I think what cuts against the appellee's argument in this particular instance is its own response letter from its insurer. And it said specifically, the investigation reveals no evidence of negligence on the insured or their employees. So clearly...
And does it say no evidence of negligent... I mean, your point now is that you really were about negligent maintenance, correct?
Well, I think it's both. I think it's...
my question, I'm sorry to interrupt you, but my question was, does the insurer's response identify that the negligence being discussed is about maintenance and not design?
It mentions negligence of its employees and insureds. It's part of the appendix, the response letter.
Sorry, I didn't look at it. I
No,
apologize.
But I take it would you concede that if it's negligent design, it's a discretionary function claim that can't be brought?
Absolutely not. Absolutely not.
When negligent design is...
I don't think that the type of area that we're talking about rises to the level of the town's discretion as required by Chapter 258, Section 10B. When you look at that test, number one, is there discretion? Well, I guess in the broadest sense, the town had discretion as to whether or not they were going to put a bullpen mound in that particular location. But the second part of that test is most important here. Most important. The discretion has to rise to the level of weighing alternatives, making choices, public planning, policy making. This is governed by a Department of Public Works, a Parks Department. So presumably, if there was that kind of government policy making, there would be meetings, there would be reports from architects, there would be meeting minutes, something to show that the decision makers of the town actually weighed alternatives. Well, we can't allocate funds for that bullpen, we're going to allocate funds for this dugout over there. And there's absolutely no evidence on the record whatsoever that the town of Hudson did anything like that.
Well, how do you, I mean, if that's the case, if I'm remembering correctly, Justice Lank's decision on the appeals court, Dunn versus the city of Boston, was about the discretionary decision about when they were going to repair the steps for City Hall, right? Am I right?
Yeah, I think that's right.
So, I mean, that seems to me, I doubt the city council met and debated and whatever about when the city was going to repair the steps to City Hall.
Right, but in terms of a discretionary design, how this field was initially laid out or refurbished perhaps, there has got to be an indication that it reached that level of decision-making, that there were choices, allocations, and that type of thing. There's not even a meeting minute that was submitted from the town of Hudson to show that it rose to that level. What you have is an employee and students that use the bullpen mound, as the record indicates, maintaining it, putting it in there, that type of stuff. I would submit very highly that it does not rise to that level of decision-making that brings it into the discretionary function.
Is it different for the lighting, which is one of your claims?
I think the lighting goes to poor maintenance. You know, there was a light pole in the general area, but it was clearly dark. It was not up to the type of amps that would be required.
With regard to the lighting, you'd be limited to negligence and not design. It's not as if they should have put more lights in the stadium.
Absolutely. Absolutely. But the other thing, if I could go back for 1 second in terms of the notice, I mean, even if the court were to find that initial notice not specifically detailing the negligent maintenance, which I would submit to you it did in terms of the response that was received from the town, there was a second notice that was sent, and it was in response to that insurer's notice from the town of Hudson, and that clearly indicates that there was negligent maintenance. So I think when the court taxed those
Remind me, that was a timely second notice?
Absolutely, yep. It was in response to the letter that we had received from the town of Hudson.
And it was within the 2 years.
Oh, gosh, yes.
Thank you, Council. I think
All
your
right,
time
thank
is
you.
up.
So,
No, you're done.
Oh,
You're done.
okay.
You're done, but thank you.
thank you.
In fact, you're more than done, but I appreciate that.
Good morning. May it please the court. My name is John Davis. I'm here on behalf of the town of Hudson, and we ask this court to affirm the summary judgment entered below. I'd like to address the issue that was raised by the panel with respect to the access to the field at the time. I appreciate that at the time of this game, when the plaintiff was injured, 2 high school teams were competing and other people could not use the field. The notion that that exclusive use for 2 hours or however long a high school baseball game lasts means that the landowner, the property owner here, the town of Hudson, would lose the benefit of the recreational use statute is absurd in the sense that you'd have to. The Wilkins case, which talked about providing protection for the general public, is an equal access case. If I'm a property owner and I make my land available to everyone, the general public, I open it up, whether it's a tennis court or a basketball court or a football field or a baseball diamond, I open it up to the general public. It doesn't mean I can't tell you to take turns. It doesn't mean that everybody can use it all at the same time.
You don't even talk about Wilkins in your brief, I don't think. But Wilkins was a case about the school is open during the day to anybody, but at night, when this parent-teacher conference was going on, it wasn't.
And this park was open to everybody. At the time of this game, the baseball diamond couldn't be used by everybody. You have to reserve time. In Marcus, which this court addressed with respect to the park in Newton, where there was a softball league going on, the court talked about the fee, but the fee was paid so that that particular team could use that field exclusively for 2 our blocks during the course of that summer. And I appreciate that maybe that issue wasn't raised there, but in dicta, the court suggests that if you could trace the money, and the money only went to reimburse the city for the administrative costs attributable or allocable to that particular use, then the city would get the benefit of the statute. But to suggest that we cannot schedule, we cannot allow people to sign up, even though their use is still free, that we cannot allow people to sign up. We have to allow wide open, equal access, simultaneous access to the tennis courts, to the football fields, to the soccer fields for practice, what have you. No, we can't kick them off, otherwise we lose the benefit of the statute, is absurd. And in fact, even in Wilkins, this court recognized that you can have reasonable restrictions. There's a footnote 5 in Wilkins where this court said that with respect to restrictions, such restrictions even may include limiting the number of people allowed on the land at a given moment. That's exactly what we're talking about, provided that the method for doing so preserves equal access by all members of the general public. That's what we're talking about. We're talking about equal access by the general public to the land. We're not limiting who can use the field. We're not limiting who can use the park. We're simply saying that when somebody is taking their turn, not everybody can use the baseball diamond at the same time.
Can we turn to the other argument? If the pitcher happened to play for the Hudson team and not for the away team, would the recreational use statute protect you?
With respect, if the player was on the Hudson team?
Right.
Your team.
Yes, if the player is on the Hudson team, then he, based upon the Alter analysis, there is a special relationship between us and the Hudson player because he is our student. There, in the Alter case talks about the notion of in loco parentis.
But if you have, on that score though, if you're part of the MIAA, this was I don't know if it was a championship game, but this is a competitive thing that your school is very much involved in. So why couldn't you look at the players in the MIAA in which you are a participant sort of fit within the same class?
I think so. We would have to expand the people to whom we owe a special relationship. Okay. And if you go down that path, you'd have to have some rationale for it because there's certainly nothing in the recreational use statute. The Alter case is really carves out a judicial exception to the recreational use statute, which hasn't been changed in over 20 years. So I appreciate that the legislature isn't upset by the Alter decision. But by
something about, they can't play baseball or softball, whatever this was, by themselves, right? So, I mean, there's just something bizarre about limiting it to Hudson students.
Well, I think it's no more bizarre than to suggest that if this particular plaintiff was playing in another league or playing against other opponents, he would be subject to the recreational use statute. But to suggest that he is not subject to the recreational use statute because his opponent is somebody with whom we have a special relationship, it doesn't make sense to me to extend that special relationship to everyone in the game.
But isn't the fact that when a school invites another school to play baseball or any other sport, the expectation is they're going to provide a safe field to that other school so that those students are not in danger? By your rationale, the visiting dugout could be a rat hole, and there would be nothing that would protect the other school from or the students from the other school from whatever dangers may lurk in sitting in a rat hole while they await their time at the plate.
I would suggest there may be other factors at play if that were the case, Your Honor. But again, if the recreational use statute, if you can't get out of the recreational use statute, or if you're going to apply the Alter case, then you'll have to say that we have a special relationship. We have a special relationship with the opposing team, and that arises what? Because of the in loco parentis? No, in loco parentis applies with respect to the visiting player and his team, his coaches, his staff that are there for the same game.
You think that it only depends on in loco parentis?
That's the basis of it doesn't say so. You know, the case law that the appeals court relied upon talked about, it cited, I think, 4 different cases, all of which are in loco parentis cases. The notion being that when a parent leaves a student in our care, we have the authority to discipline, we have the authority to maintain order, but commensurate with that authority is the responsibility to protect, to supervise, and oversee that particular student. So the Kaler case was a middle appeals court case, where they said in that case the recreational use statute did not apply because that student who was injured on school property was not a student of that school. I mean, that's the rationale, I think, when you're talking about somebody else outside of school hours, perhaps, on school property. We don't owe a special relationship to everybody that may come to our property, whether you'd be talking, I guess.
But the difference is that you invited them to play your team. It's not anybody on your property. It's the team that you specifically invited to play your baseball team.
And I would suggest, Your Honor, that if you talk about invite, the statute specifically says, don't go there. The statute says you can't, based upon the invitee or licensee, even that status of an invitee ought not to change the application of the statute. It's right in the statute. And the Bailey Aldrich in the DeMella case, in Ferreira case by the appeals court, they said that distinction is amorphous. The fact whether I simply permit them or I invite them, it makes no difference whatsoever with respect to the application of the statute.
Does the MIAA require schools or teams to provide insurance to their players when they're visiting, in circumstances in which they're visiting other schools?
I don't know the answer to that, Your Honor. I don't know the answer to that. But the invitee language, Your Honor, is in Chapter 21, Section 17C. It says such permission, if we're granting permission to someone to use our property free of charge for recreational purposes or educational, what have you, shall not confer upon any member of the public using said land the status of an invitee, to whom any duty would be owed by said person. So you can't go there. I would suggest that the
we're putting it not in the invitee realm. We're putting it into the responsibility that a school owes to its students, and that when a school invites students from another school to play an athletic event against their school, they have responsibility for both teams. That would be the principle. I mean, it wouldn't be a general invitee principle. It is a principle, essentially, of common decency of whether a school is going to not provide a safe environment for the opposing team to play. That doesn't seem to be so bold a standard.
Well, I guess I would get back to you, Your Honor, if we're talking about the premises that we provide, whether it's the field or the dugout or what have you, there are other factors at play. If the legislature has said, and I'm trying to interpret the statute itself. This is a legislative interpretation. If the legislature wanted to carve out an exception for people that we have, please come to our property, use our property. If they wanted to do that, they could have done that. They didn't do that. This court, in the Molinaro case, said, look, with respect to children on playgrounds, there's no exception in the statute. We're not going to carve out an exception in the statute. I think what you'd be doing, in effect, Your Honor, if the court goes down that path, is you're carving out an exception to the recreational use statute because we have invited them to come to our property. And maybe it's because we think that they're minors, and therefore minors are entitled to greater protection. The statute specifically says that without limitation, minors will be treated the same as adults. So I suggest, Your Honor, without support in Chapter 21, Section 17C, the court can't go down that path.
Perhaps the mistake a time ago was to extend this beyond private landowners.
Perhaps, Your Honor. Perhaps. I mean, but then that is now, at first it wasn't specifically in the statute, but then the statute was amended to make it clear that it applies both to private and public landowners. And I would suggest that based upon the amendments in 1998, when they went from recreational to include educational, charitable, scientific, a number, eight other social uses, it's a substantial change to the common law premises liability to say anytime any public or private landowner opens up their property to a user of that nature and they're objectively using it for recreational purposes, it raises the bar for recovery. I think it's a substantial change. And you'd be talking, I think, you have to appreciate that it doesn't just apply to outdoor facilities. It would apply to indoor facilities. So if we're talking about a library or a community center or an auditorium or stage somewhere, a gymnasium somewhere, if you are going to go down that path, you're talking about those places as well. Whenever anybody we may open it up and invite people to come in for what have you, then you're talking about those places as well, because those are also part of the property that would be qualified as recreational or educational or what have you. If I may, I'll address the other two issues that the court below did not rely upon. With respect to presentment, there are claims that were both presented and unpresented. We maintain that the presented claims, that the original presentment letter talked about three things that have to do with design. They had to do with the width of the bullpen. It had to do with the use of materials. There were wooden timbers that the plaintiff maintains were inappropriate for a bullpen. And finally, there was lighting that the plaintiff maintains was inappropriate for a night game. And those claims, traditionally, there's the Petraza case, there's the Fortenbacher case. We've cited those cases in our materials. Traditionally, unless you can identify a particular statute, regulation, or standard adopted by the particular agency that is controlling, then it's discretionary. And plaintiff says, well, it's maybe the level of discretion here, the DPW, what they pick to do. I mean, we're talking about the allocation of limited resources. If the town had unlimited resources, I imagine they would have built state-of-the-art facilities. They built what they built in part because they had what they had. And those are the types of things that are typically protected as discretionary under Section 10B.
What do you say about the claim that it was maintenance that's at issue?
Well, we maintain, Your Honor, that that was not presented, and I appreciate that Plaintiff's counsel did send us a follow-up letter. The follow-up letter was a 93...
Was it within the time?
It was within the time. It was not sent to the town. It was sent to the claims administrator
That's who answered the first letter.
Yes.
It's not unreasonable to be communicating with whoever it was that the town had designated
Oh, well, the
to
town
respond
had...
on its behalf.
The town has insurance, and they tendered it to their insurance company, and I appreciate that. But this is not a situation where the plaintiff tries to tack on those letters. This court has always been very careful about, even if we're talking about content of, was this alleged or was that alleged, it's been very careful about making sure that the letter is sent to an executive officer of the public employer and that it's sent within 2 years. The follow-up letter was sent within 2 years, but it wasn't sent to the executive officer. It wasn't copied to the executive officer. There's nothing in the record to suggest it ever made its way to the executive officer.
Well, the plaintiff argues that the letter that the insurer, the response of the insurer to the, I think, to the original notice indicates that the responder interpreted the first letter as talking about negligent maintenance.
The letter is in the record, Your Honor. I wouldn't interpret it that way. I mean, it does. The letter, the original claim letter, did not talk about maintenance. The follow-up responds to the allegations that are set forth in that letter. I mean, the presentment requirement is, bottom line, a notice requirement. And a notice of what? You have to allocate, you have to articulate what your claim is based upon. Negligent or wrongful act or omission. That's what the statute says. So if you identify in your letter, you identify negligent supervision, negligent hiring, and then the insurer looks into it, and they say, hey, we don't see the basis for a claim, and we're not going to pay your claim. That was the nature of this response here. They did not see a negligent design case, and they responded accordingly.
Well, if there were more than that, you don't think that the executive officer could designate impliedly someone to communicate with on its behalf?
I think that
agency kind of principle.
I think that could be a possibility, Your Honor. There's no evidence in the record to suggest that was done, but an implied.
But I don't think presentment is supposed to be a trick.
I don't believe it is supposed to be a trick.
Well, I mean, if the town gets notice to begin with in the first letter,
right,
and then hands it over to the insurer communicates, and the insurer communicates, I think, more broadly than just as to design. I think fairly read, and the follow-up letter then goes to the insurer. I don't think it's an unfair inference to draw that the town has designated the insurer as its agent for receipt of information relating to the claim.
I would suggest it is, Your Honor, in the sense that the insurer has certain interests of their own as well, in the sense that the follow-up letter was a 93A demand, saying that the insurer had engaged in bad faith, unfair, or deceptive acts or practices, and then the insurer responded to that. So to suggest that this was just a communication by the insurer on behalf of the town would be, I think, in this particular case, if you read the letters, inaccurate.
But going to the first letter, it also says that the town was negligent in allowing them to utilize the bullpen area, which is inherently dangerous. Is that not a pure negligence claim?
Oh, It's a negligence claim by all means, Your Honor. And just invoking the word negligence doesn't give me much guidance since Section 2 says.
The claim is not. The claim basically says this was an inherently dangerous place, and you should not have allowed them to warm up in that bullpen. Is that not a negligence claim?
It's not a negligent maintenance claim, Your Honor. It's inherently dangerous, and then they articulate the reasons for why it's inherently dangerous, all of which go to design. But
Then it focuses on the conduct of the town in allowing them to use that bullpen as opposed to the design of the bullpen.
in allowing them to use an inherently dangerous, I
Basically, the
agree that's what
bullpen-
it says, Your Honor.
So, but isn't that, I mean, that's not a negligent design claim, that's a negligence claim.
I'm sorry, Your Honor, I don't read it as you had timbers there and they were worn out and they were out of place. You had
Right, that arguably is a negligent design claim, but this also articulates a claim to say that was a dangerous spot and you should not have allowed people to warm up there. You should have said, no, that area is verboten because it's too dangerous. And it was negligent for you to allow them to warm up in that area. Is that not a negligence claim?
It is a negligence claim, Your Honor.
Okay, thank you.
Thank you.